Okay, here we go. Let's do it. Can you now?
Yep.
Great. Amazing. Okay.
Okay, everyone. Thank you so much for coming to this second breakout session. This is our second and our last breakout session. Just a reintroduction, my name is Dylan Wildman. I'm the master of the moots. And with me today is Belinda Tan, the mistress of the moots. So today's breakout session is all going to be about performance and etiquette. So the last sessions we were talking about were, exploring the demo moot and then exploring into the research process behind the mooting competitions. Now we're going to just delve a little bit deeper into how to be the best and the greatest mooter possible, and distinguishing you from someone who's good and someone who's great. So it will start.
Okay, so here's a little recap of the demo moot problem. Basically, the grandmother took responsibility over her granddaughter, taking care of her, but she was smoking, drinking, whilst, taking care of the child. So she forgot to close the door properly, and her dog came in and attacked the child, and the child died as a result. So that's just a little recap of what the demo moot problem was. We will be including this in our Moot Bible, which we will share with you later on. But yeah, that's now. So just a little refresher of how the Moot is going to go. Obviously, you guys already received the email from Marin and Amalik. So your moots are all next week. The lead appellant will be 7 minutes. The junior appellant will be 5. The lead respondent will be 7. The junior will be 5, and the rebuttal is 3 minutes. Normally, the lead appellant will be giving a brief summary of the facts of the present case. So you'll usually be given around like 30 seconds or so to kind of talk about what happened in the present case, kind of to remind the court of what is going on.
So the way to address the parties. So the parties, they're either the appellant or the respondent, or Mr. X or Mrs. Y. The judge, your ladyship or your lordship, instead of you. So you can say my lady, my lord, instead of their name. Whatever you do, don't say their name, because then that's like almost like an instant fail. The other side, my learned friends or my learned friend, the co-counsel, my learned lead or the junior counsel. And when addressing the panel as a collective, you want to refer to this or to the court. Advocacy. So the main thing that I would say is confidence. You have to think of the mooting competition as a performance. So think of the judge and the opposing team as your audience, and you're almost performing up you're almost performing to the audience in essence. So make sure that you therefore like emphasize what you're saying in the best possible way possible. So when your quality of speech, you need to have a good pace, pronunciation, your voice needs to just be able to be very projective, and have very good tone of delivery as well. So make sure you're emphasizing key things, employing some dramatic pauses, and just making it seem very, very dramatic and very performative. So make sure you have clarity of your initial submissions as well. Of course, you can go into more detail when you're advocating, but make sure that if your submissions are initially very succinct, it's easier for you to speak and elaborate into what you've spoken about. And also, it's easier for the judge to understand what you're saying, and also the persuasive delivery and appropriate language.
Okay, so I think we talked about this in our previous workshop. So with the whole performance idea, you have to use buzzwords. So based on the demo moot problem, it would be like, okay, the grandmother, you know, self-volunteered. She took on this duty of care and she grossly breached it. So kind of emphasize all these little words to kind of capture the judge's attention and obviously consolidate your argument. Yeah, that just plays into the whole performative aspect of mooting. Um, a very important thing, try not to excessively gesture with your hands because it is very distracting. So like if I'm talking right now, but like you can't really, it's like very distracting that I'm moving my hands to the judge, because not only are you on a time crunch, the judge is on a time crunch to kind of follow through your arguments, and they're trying to understand what you're saying. So if they're just going to look at what you're doing, it's not going to help your side. Because the first year competition is a moot, a virtual moot, it is very important that your connection is well and the judge can hear you from the beginning. Even in a physical moot, it's going to be all masked up. So make sure that the judge can hear you properly. So it just eases the process of being able to have your clear and concise arguments heard.
So beginning a moot as the lead appellant. This is the golden structure that you definitely should follow when you're leading the moot. So may it please your lordship, my name is Dylan Wildman and I appear in this case with my learned junior Belinda Tan on behalf of the appellant X. My learned friends X and Y appear on behalf of the respondent X. I'll be contending the first ground of appeal, which is Y. My learned junior will be contending the second ground, which is Z. Before contending the grounds of appeal, would your lordship appreciate a brief acquaintance with the facts of the case? If the judge was to say yes, just make sure that it is brief, because you're on a time crunch, as Belinda was talking about, so you don't want to cut in too deeply into the time that you have. In relation to the first ground of appeal, I have this submission to make, and you outline your submission, and then you ask if you are able to proceed with your first submission. So as the lead appellant, you could also say, if it pleases your lordship, my name is Miss X and I appear today as senior counsel for the appellant. My learned friend, Mr. Y, shall be acting as junior appellant, while my learned friends, Mr. A and Miss B, shall be appearing on behalf of the respondents. Or may it so please the court that I am Miss X, acting as senior appellant. My learned friend, Mr. Y, shall be acting as junior appellant, while Mr. A and Miss B shall be appearing as senior respondent and junior respondent, respectively.
Okay, so for the rest of the council, you just say, may it please your lordship, as had already been indicated, my name is Belinda Tan, and I appear for the respondents on the second ground of appeal. I have 2 submissions to make, and then you outline your submissions. Obviously, the submissions are what you put in your skeleton argument, and we do have a sample skeleton argument in our Moot Bible. We're so excited for you to see it, actually. But yeah, that's what you say the rest of the council says. Also, other rules on advocacy: when you ask, when the judge asks you a question or request and you answer, you say, okay, I'm much obliged. Or if you ask, okay, may I proceed with my first submission? And then they say yes, you say, I'm much obliged, rather than thank you, because that's etiquette. This is really important when referring to cases. The V in the case is not pronounced as versus or V, it is pronounced as and or against. You also learned this, I'm pretty sure, already in law school. You don't pronounce it that way. It's only in the States that you pronounce it that way. R represents the crown. So here are some examples. So you would say the crown and Gibbons and Proctor, or the crown against Gibbons and Proctor, and then Telk and Moxhay. And as for judicial titles, you don't say Smith J. You would say Mr. or Mrs. Justice Smith, or simply just Justice Smith. And then again, you don't say Smith LJ, you say Lord or Lady Justice Smith. So these are very important things that you need to remember when referring to the judge. So if you need a little more assistance, you can just go search up judicial titles in England and Wales. It's very different from the one in the States, so please make sure that you get that right. So in terms of referring to the law, you're not only going to refer to the brief summary of the facts of the present case, you're also going to be referring to all the different ones, all the different authorities that you have laid out in your skeleton argument. So please just prepare bullet points. You are on a time crunch. Like I said, the lead appellant only has the lead counsel only has 7 minutes. The junior counsel has 5 minutes. So you don't want to read the whole summary that you get from e-law resources or law teacher. You will have to just break it up and just say the important points. And also for the cases that you are going to be referring to, if you're not going to be relying on the facts of the case, please let the judge know so as to just save time and just say, okay, I will be relying on the principle rather than the facts of the case, so that you can just save time, shorten it, and it will just be good.
Referring the law. When referring to a case for the first time, you must cite the case name in full. For example, Partridge and Crittenden, 1968, the First World Law Reports, 1204. So these are the different ways that you can articulate that. So you can say, if I may refer your lordship to Divider 1, this is a case of Partridge and Crittenden, reported in 1968 at page 1204 in the first volume of the weekly law reports. So that itself is a very good structure. But as an alternative, you may be able to say, may I direct your lordship's attention to the case of Partridge and Crittenden, reported in the first volume of the weekly law reports for the year 1968 at page 1204. It's virtually the same thing, but again, it's important for you to refer to the whole citation, and then after you can humbly request to dispense all citations. If permission is granted, you can then refer to the case using only the party names. So for example, Partridge and Crittenden.
Okay, so based on the demo problem, this is the example. So it says, please may I refer your lordship to the case of the Crown and ADVOCACY, which can be found on tab 4, page 9 of the bundle. Obviously, for e-bundles, you don't have any tabs or anything, so you just say page 9 of the bundle. And then you say this case was reported in the first volume of the law reports for the appeal cases in 1995 at page 171. This is really helpful even for like your academic articles, all your assignments, to know how to read citations. So this would be the volume number. This is the court that it appears in, or sorry, this is the law report that it is in, and this is the page number that this case is within that law report. So ADVOCACY is in page 171 of the law reports for the appeal cases. But yeah, this is a really good skill to know, even for academics. And if you want to know like more abbreviations, you can check out this website as well. So when you're referring to cases in the bundle, you would have to, it would be much easier for the judge to follow what you're saying. When you say, okay, please may I refer your lordship to page 8, which is here, subdivider B, but subdivider is basically for the physical ones. So you can just say paragraph B and then highlight it in yellow. And then if you and your partner are using the same page, just try to use different colored highlighters. So if your partner is using the same page, just like highlight it in like green. But if you're using the same quotation, obviously you would just say highlight in yellow. And it's the same with statutes. It's no different, just page number and then paragraph.
Referring cases. You're expected to have 2 bundles, so one for yourself and one for the judge. E-bundle for virtual. Physical bundle. These are black ring binders containing your skeleton argument and copies of every single authority contained in the skeleton. A contents page and a copy of the MOOT problem can also be included in your own bundle. It's just very important, again, with the bundle, that everything is sent on time. This is what we'll talk about in our last breakout session, but the organization element is so important. So you don't want to just serve yourself at a disadvantage if you're not presenting things in the best way possible, or your organization of when it's supposed to be sent off is out. So just make sure that you're very pedantic in that regard. Do not highlight really large chunks of text and try to paraphrase when possible. This is just because if you are in the process of articulating your submissions and you refer the judge to the bundle and it has a large chunk of it has been highlighted, it's going to be so difficult for the judge to be able to like multitask and listen to what you're saying while reading through the highlighted bit. So it's always just making it easier for yourself, because what could happen is they could miss a lot of the excellent points that you can be talking about because you've directed them to something that is just too big and too significant to like be able to read in such a small amount of time. So just be very mindful of the fact that you've got 7, 5, 3 minutes to do to speak about your submissions. So just be very careful. Do not read out any sections of text which are not contained within your bundle unless the judge asks you a specific question about it. Always signpost the judge as well. That's something that is so important. And give them a second or two to refer to the page that you are. So you could, your lord or your ladyship, have sight of the passage, just because it allows it to feel more organic, the process of your mooting round. So it doesn't seem that you're reading from a script. You're actually engaging with the judge and you're waiting for them, and it's just that a little bit more personal. So it's very, very important. Concluding the moot. If you need extra time, please politely ask the judge if you could briefly finish your submissions. A good tip is if you've seen now that you know that you're running out of time and you've got maybe like a page or two left, you can be able to like mentally examine how much time you think you need. So if you ask the judge, can I please request for an additional 1 minute, for example, it just puts you back in the driving seat and it gives you much more control in the situation, because they understand that you've got a lot of brilliant points, but it's hard to get them all in the specific time period. But if you say that you want like an additional 1 minute, it just shows that you're not hectically talking, and like the main points and the points that are the strongest. So you can say it like this: therefore, your lordship, I submit that briefly summarize your submissions. Unless your lordship has any further questions, that concludes my submissions on this ground of appeal. Counsel for the appellants respectfully invite the court to allow this appeal, or counsel for the respondents respectfully invite the court to deny the appeal. I am much obliged.
Okay, so in terms of rebuttal, like I said, it is 3 minutes. So normally the lead appellant would just help represent both the lead and junior counsel. So the lead appellant would just rebut the respondent's submissions. This is, again, a reminder, not an opportunity for you to regurgitate what you've just said earlier. The judge has already heard your side of the argument. The point of the rebuttal is just to kind of weaken the respondent's submissions and point out the flaws in what they've said. A good tip is to kind of catch what a direct quote maybe they used in a case judgment, and I'm pretty sure you guys all read the same cases, similar line of cases. So you would use that quote and say, okay, well, they said this, but this is actually, helping our case in X, Y, and Z because of X, Y, and Z reasons. And then obviously when they're, making their presentations, when they're mooting, when the respondents are mooting, mainly the lead appellant would have to take notes because they are going to be rebutting, but the junior appellant can also help. So they'll just take notes when the respondents are talking. Here's a little process of how the whole rebuttal process thing looks like. It's pretty simple. Number one, obviously, briefly outline the points you're going to make. A good tip, actually, is to kind of preempt what the respondents will propose in their mooting. It helps the process easier, and it help you like organize all your thoughts properly. You are allowed to refer the judge to your bundle, but usually that doesn't really happen. But it is good to refer the judge to your bundle as long as it supports your case, not just to regurgitate what you've already said earlier. So yeah, just catch what they say and then just bullet point everything. And if you feel like you have absolutely no point to rebut, like you're like, oh, I don't know how to like rebut that, just you're inevitably going to use your submissions anyway. You're going to point out something that you've said earlier, so you can use that, but try to reiterate like the strengths of what you've said, like, okay, we said this, they said this, but this is our reasoning, and this is why you should consider our side. There hasn't been a moot where any of the appellants have refused a right of reply, because this is the perfect opportunity to consolidate your argument and just remind the judge of what you've said earlier as well, just weakening the other side.
Judicial intervention. Tip, do not look thrown off by the question. Always try to maintain your composure. So you can say, thank you, my lord. This counsel appreciates your question. Thank you for your question. This counsel would like to respond by directing your attention to the fact that. So ideally, even if you're really, really thrown by the question, you don't want to give the impression that you are thrown by the question. You want to be as neutral and as confident as possible. So drawing back to what I was saying previously, confidence in mooting is so important because, as I said, it is a performance. So you just need to be aware of your facial expressions and your body language as well when responding to the judge's question, because it's designed to, almost put you on the spot to test your spontaneity, but just make sure that you are able to respond with a way that is, composed and relaxed. And even if you have to take a second to just like reconsider your thoughts, then that's fine. But just try your best to give the impression that you know what you're talking about. After intervention, make sure the judge has processed or heard your answer before you continue. So, for example, you can say, may I proceed with my submissions? When they say yes, you say, I'm grateful. If you don't understand the question, it's so important that you stay calm. Politely ask the judge to rephrase it, and they will do. And then take a few seconds or so just to collect your thoughts and really, really process what has been said. I think the best thing to do in that situation is to really examine maybe the key premise of the point that they're asking, and then try to link it into any legislation or relating it back to the case facts, and just work in almost that systematic way, just like that.
Okay, things to avoid. A lot of people, including myself, have read from a script before. It is obviously a given that you need a document, even if you're physical, like online, you'll need a document to refer the case within the bundle. Okay, please may I refer your lordship to the case of this is. You need to take notes of all of that. You also need to take notes of the cases that you're talking about, and your main arguments. The biggest mistake is just reading verbatim every single thing that you've written on the document, because it just doesn't make any sense. It's like you're not even communicating with the judge. The judge will notice that. So try not to, if you're going to have a document, try not to just like make it so obvious. Like I'm reading this right now. You can see that I'm not looking at the camera. Yeah. So in terms of etiquette, always try to remain neutral. Like this girl, don't make faces like her. Don't make the faces like her, or frown, or pull any faces, or like just disagree with what the opposition has said, or don't even nod in agreement with what the opposition has said. Try to remain a neutral and just be polite to everybody when they're mooting as well. Yeah, I think when you nod in agreement with the opposition, it just like doesn't make any sense because you're kind of supporting what they're saying. Yeah, and it also applies like a lack of confidence as well. And another thing is this one. This is really, really important. This has happened before, and all judges do not like it when you try to avoid their question or delay what they've asked. So if they've asked you something that you are going to address in your second submission, answer it right there and then anyway. And then you can say after you've answered them, and then you proceed with the second submission that they've asked. You said like, oh, as mentioned earlier, I pointed out X, Y, and Z. So don't avoid them, don't delay their questioning, because their logical reasoning is at a different pace than yours, and they are trying to articulate it in their own terms. So always try to make everything comfortable for the judge, answer everything they've asked, and that will just help with your case.
So now your etiquette. So it's going to be online over Teams. But just because it's over Teams doesn't mean that you shouldn't wear. So that would be suits, blazers, preferably wear headphones, just so it's easy to hear you. If you're standing, make sure the camera is adjusted accordingly. Using e-bundles or having it open whilst you move, either write down the quotes or the page number or the paragraph number in your notes so you're not constantly flicking from bundle back to teams during the move. It's just, again, to help you with your momentum as well. You don't want to just randomly, be at a point where you're between pages and then you're stuck because you're trying to get to know what I was saying before. So it's just making everything run smoothly. Just small details that you can do outside of the round. Just making sure you've wrote down what page or the paragraph you want to refer to. Look down the camera directly when you're speaking. Try to maintain eye contact. Have a clean, clear background with minimal background noise. So yeah, we're aware that some people are still at home, so it might not be as easy, but just try your best with what you can do. If your connection lags or breaks up, apologize to the judge and request for the extra time that you lost. They're sure to give it to you. If it isn't your turn, mute your mic. I've got the opportunity to be able to speak with no distraction.
Oh, I think Dylan is also kind of breaking up right now. I'm not sure if it's just me, but hopefully you guys can hear Dylan because I can't really hear him that well. But yeah. So last week, we've touched a lot, and even the week
Can you
before.
hear me?
Yeah, I can hear you now. Okay, great. Um, we've touched a lot on bundles and the skeleton submission. So we're going to talk about legal understanding, originality, and analysis. So these are things that we're going to touch on right now. So what is legal understanding? Based on the demo problem, we know that she was negligent. So negligence is one of the issues. And the main issue, I mean, as I've kind of demonstrated last week, how to find like key words, key phrases to kind of find significant key judgments in relation to those phrases. So foresight of death would be one of the issues. Mens rea, obviously, recklessness. And the main thing is the importance or non-importance of foresight of death in the assessment of GNM. So that is the main issue based on the demo problem. You have to use key authorities. As we've demonstrated, Adamako was mentioned in the case itself, so you will obviously have to use Adamako. There's also like Misra, Bateman. All of these cases are related to each other, and we've demonstrated that through Westlaw, they're all connected and they all have significant. They're all mentioned in Adamako, and so you'll have to use those authorities. Also, when you refer to the judge or when you're making your argument, you refer to authorities, not what the counsel is making. You need to understand both sides of the legal argument. This is really important, especially in judicial intervention, because a lot of the judge's questions are based on what the opposition is saying. So if they're going to ask you, okay, what the respondents have said, this, how do you rebut that, and how do you reason out of it? So you always have to try to preempt questions, and even if you didn't preempt the judge's questions, you will already know what to expect. So it's good to be prepared. Also, when we refer to cases, you need to do all the citations correctly. Your points will be docked off if you say like R versus Kennedy or something like that. That is not correct. It should be the Crown and Kennedy. And then, yeah, you have to show some research, depth of research and preparation, especially in judicial intervention.
Read the judgment through and through, use every bit of the judgment and try to use it as to your advantage. So this case is basically on the respondent side. So you need to be very, very smart in the way you approach it. So make sure that when you read through and you do like a proper scrutinization of the argument, that you can see maybe small details that you're able to extrapolate and then just use it to your advantage to the best way that you can.
Okay, so like Dylan said, the demo moot problem, the law and the facts of the case are pretty much against the appellants. But this is good because this is the opportunity for you to be creative. A lot of times when you're the appellants, I mean, when the law is against you and everything, you use policy arguments. And so in the case, the grandmother was smoking marijuana, and she was drinking and all of these things. So smoking marijuana, okay, that's kind of normalized right now. So you can kind of say, oh, should we really criminalize her for, using to standard of care on the basis of, a self-medicating strategy or something like that. Or a little more, or another policy argument is like, okay, is, the threshold is way too high if you hold her to a high standard of care. So then she shouldn't be held criminally liable. This is supposed to say the opposite. Apologies for that. But yeah, that is just a way for you to be original and creative. Try not to be too far-fetched, because there was an argument made about how the grandmother had to take on the responsibility to take care of her granddaughter because her mother, how dare she, went on a vacation in Ibiza. So like that is not that is creative, but it's a little too far-fetched. But yeah, try your best to stick to reality a little in terms of originality. Yeah.
To the analysis of scenario and construction of argument. So you need to make sure that all of your points are relevant to the ground of appeal and that they're supported with authority. So whether that's cases, statutes, articles, if the area of the law is uncertain. Convincing arguments need to be made, logical and structured arguments, linking arguments and authorities to the problem facts effectively. So as Belinda was saying in, I think, the last breakout session, just employing the idea of IRAC and the issue, rule, apply, and conclusion. That structure is very, very effective because it makes sure that you're hitting all of the, I guess, assessment objectives, as it were, and making sure that you're standing out amongst the crowd. For the lead appellant, ensure that a rebuttal is well structured. So a good way to think about this is if you have almost like a beginning, middle, and the end, and you structure your rebuttal to kind of strategically dissect what the opposition has said. So making really hit what they have said, not just drawing upon, as Belinda will say, not just drawing upon like the points that you already have or you already prepared. Make sure you actually deconstructed the points that have been raised by the opposition.
Okay, so this is how the feedback form would look like after each mooting round. As you guys have received a couple of emails from Mary and Amalik, if you guys haven't signed the availability or filled in the availability form, please do, because we're releasing the mooting problem later today at I think around 6. So please fill in the availability if you haven't yet. But I think they've already settled it. They've worked very, very hard over the past few days. So please try to be cooperative and reply to emails as soon as possible and reply to all their requests as soon as possible. But this is an example of how this is a sample of how the feedback form looks like, and this is what you will receive after your mooting round. Mary and Amalik will chase the judges who judged your round. If you have not received the feedback form yet, you can just let them know, email them, all that stuff. But yeah, we have the positive comments and then areas of improvement. Please don't be offended. Try not to take it emotionally, because it is good constructive criticism. It is the best. I think it's the key thing for you to become the best mooter you can be. So use it as constructive criticism and say, okay, I can improve in this area. I can, improve in my advocacy, in my legal analysis as well. So don't take it to heart, I guess. Just use it as constructive criticism. I don't think the Mooting website is updated yet, but we have a sample e-bundle, and we have the Moot Bible, which we will include in the email that we will send to all the HSF first year competition participants later on. So it will be included in the email. It is not available on the website yet because the entire website isn't updated. But we will be including the Mooting Bible, the Moot Bible, and the sample e-bundle in the email releasing the timetable as well as the Moot problem. So we'll include those as well in the email. So please check it out. Please check all your inboxes. very, very important to know when your mooting round is, because we're sending all the teams invites. A lot of you signed up, so please just make sure that you know when you're mooting, and which side you're mooting for. So, for example, if you're appellant in prelim 1, you'll be respondent in prelim 2. But yeah, we're really excited to see you guys moot next week. It starts it's from the 25th to the 27th. So yeah, these resources will be available in the email, so check it out. But yeah, the website isn't updated, so we don't really recommend you go there. But yeah, we'll include the updated Moot Bible and all that stuff in the email.
So thank you so much for attending this presentation. We hope that it was very, very useful for you. So yeah, this concludes our breakout series now. So if you have any questions, don't hesitate to ask. You can either unmute your microphone or you can drop the questions in the chat. And if not, you can message us directly on WhatsApp and we'll get back to you. But yeah, we look forward, as Belinda was saying, to seeing you all mute. So we wish you the best of luck. And yeah, mooting love.
Yeah, I've also included the Moot Bible and the sample e-bundle into the chat. In case you missed it, just for, additional assistance, you can just check it out before you get the problem question and all that stuff later on in the evening. Don't be scared when you first see it, because you might think that like you have no idea. You're like, oh my God, what is going on? But as you read through it and you reference your textbooks, it's all based on your course. So you will eventually learn the material if you haven't. But yeah, we're really excited to see all of you guys moot. It starts next week, like I said, so please check we are going to send out a very large email to all the participants later, including the Moot Bible and all that stuff, and the timetable. Please check it, because we're going to send meeting invites. Very, very important. Very important to check your emails. And Emily and Mary, honestly, big like applause to them. Like they not slept. So please just reply them and reply as soon as possible. Fill in everything that you're supposed to do. But yeah, that is kind of it for today's session. This is our last session for this term. It is recorded, so we know that a lot of you guys have seminars right now or have other stuff going on. So we're really, really happy that we're able to record the session. All our sessions are available on the Warwick Law Society YouTube channel, so you can just watch us again when you are preparing for your moots next week. But yes, thank you guys so much for coming. If you have any questions, you can just put it in the chat, or you can just personally message us. I've gotten quite a bit of PMs on WhatsApp from all of you guys. So yeah, thank you guys for coming, and we will see you in the moots. Yes. Thank you, Priyam. I'm sorry if I mispronounced your name. So sorry, but yeah, thank you. Yeah, we're really, really happy. We're so excited to see you guys. Like, honestly, so excited to see like all of you guys moot. And I know our judges are too. Yes. So you guys can just leave the call, and I will end the recording right now.